everyone. Please be seated. We are here this afternoon for the submission of two cases. The case of Teresa Rarick and Richard Rarick versus Smith and others is hereby submitted without oral argument. Our first oral argument of the afternoon is Stoltze versus Grace Stokes and Macaulay Stokes. Mr. Kragnes will go first, and I want to make sure I pronounce your name correctly. Is it Erbe?
That's fine, Your Honor.
Well, how is it? You know. Erbe. We had a dispute in the back about it, and thank you for settling that dispute. Some thought Erbe, some thought Erbe. Thank you. We'll start with Mr. Kragnes.
May it please the court, counsel. This case is about finality. Final means final. This court's prior precedent under Franzen v. Deere states that once a judgment becomes final, no appeal or timely motion is filed, the district court's jurisdiction terminates, including its authority to enter or modify that particular judgment. As such, the attorney fee award and order of June 17th, 2024 came after that point and must be reversed. The key facts related to this particular case, Your Honor, and I'm not going to get, Your Honors, I'm not going to get into the underlying case. We're only here to discuss the attorney fee application, was that on February 24th of 2024, a decree was entered with no fee ward, and no reservation. No 1.904 sub 2 motion nor appeal was taken. And a fee application was then filed on March 26th of 2024, 31 days after the final judgment. In other words, 1 day after finality. On June 17th, pursuant to the application filed on March 26th, the court granted $33,600 in attorney fees, albeit disregarding this court's prior case law. And the relevant case law being, one, the Franzen case that I had referenced, discussing that the court has jurisdiction if and only if a matter has been preserved. Or
what if there's a collateral issue? What if the court were to determine that attorney's fees is a collateral issue?
So, Your Honor, when we're talking about jurisdiction in and of itself, the assertion, and I believe this court's prior precedent, is the attorney fee issue itself is not necessarily a collateral matter.
Does that change your argument?
Well, in this particular case, no, it would not. And the reason that I don't believe that it would is if the court looks specifically, there it is, to Iowa Code Section 649.5 sub 3, the legislature made a very important and subtle distinction. The legislature discusses that in addition to the ordinary costs of court, which would be a corollary matter, a reasonable attorney fee may be awarded to the requesting party. They've distinguished and they've set it out. Additionally, if we look at the petition to quiet title code section in and of itself, while statutorily allowing an award of attorney fees, it's not a mandated. And unlike, for instance, the Civil Rights Code, which specifically declares that attorney fees are actual damages and shall be awarded, in the petition to quiet title action, there are precursors. There are things that have to be done ahead of time. In other words, other matters that would have to be proven, such as the demand letter being sent, such as the draft of the quitclaim deed having been forwarded, such as the check that is required to go along with it. I don't believe those then become corollary matters. Those are matters that actually put an affirmative action upon the litigants and also then render this effectively a separate money judgment. Additionally, as we look at the court and Court of Appeals prior precedent, not only do we have Franzen, we can go all the way back to Smith v. Wolf from 1881, discussing that a decree having become final, the district court had no power to engraft additional obligations upon it by subsequent order. This is effectively what we're talking about in the case at hand. When we are discussing the Smith case it is equivalent to Franzen, and it's equivalent to this particular matter. In other words, the case had become final. And at that finality, with no appeal, with no other motions being filed and no other requests being done, this court loses, the district court loses jurisdiction of any and all related matters. It's also important to note, as we go through and taking a look at the underlying case and the docket related to that, attorney fees were requested within the counterclaim. No dispute. The pretrial brief makes no mention of attorney fees. The case at hand, the discussion, the evidence presented, no discussion of attorney fees. The post-trial brief by the Appellees, no request for attorney fees. And nothing done after the court entered a judgment, a decree, stating they prevailed, but no discussion of attorney fees. Taking all of those things together and looking at the various case law that this court has established, and then also followed by Hart v. Cusack, which reinforces Franzen and Smith, a district court may consider a fee application filed before the appeal period expires or while an appeal is pending, but loses authority to do so once the case is final and no appeal has been taken. Appellees would argue that we need a bright line rule, that there should be something established related to that. We would argue and assert that that bright line rule has been established. The case law has put forth that if you are allowed attorney fees or allowed the request to do so, that needs to be done within that 30-day time frame, within that appellate time frame. Otherwise, that judgment is final, that judgment is entered, and there is no ability to revisit that particular judgment.
A 1.9042 motion within 10 days if the district court's ruling lacked any mention of the fees which had been pleaded?
Judge, I know, I believe it was City of Hampton, the City of Hampton case that the court dealt with the, I guess what was the 179B, the precursor to 1.904, and indicated that in that particular matter, no, that was not the proper avenue for which attorney fees needed to be requested, and remanded that back. That being said, that was a civil rights case. That was a case where the fees are mandatory, where they are required as a damage, and as such, that may be and have a different analysis than what we have in the current case, where they're not mandatory and they are discretionary in terms of a may. So, short answer to your well, not a short answer, I guess, Judge. Long answer to your question. We could argue that yes, the 1.904 sub 2 is a vehicle in which perhaps they should have filed to put the court on notice that, hey, we're asking for these. And that may be, in this case, appropriate. That being said, in the interest of consistency and in civil matters, and knowing as we do that civil matters do become final, a 30-day rule would be more than appropriate and would be fair to all the litigants in these circumstances.
You go ahead. Thank you. Would this apply to a motion for sanctions?
Judge, and I do believe when we were discussing circumstances of sanctions, I think, and I'm looking for the case, so I apologize, Your Honor, related to that, but I do believe we've addressed the sanction issue, and prior case law has indicated that a sanctions request should come within that 30-day time frame. However, there could be an exception carved out related to that. And that exception could be, what type of conduct are we talking about? Perhaps some sort of misrepresentation, some sort of fraud, something of that nature. But the practical reality is, as it relates to sanctions, again, in the interest of consistency and finality, when we're talking about things that come to an end, yes, it should be done within that 30-day time frame.
I'm going to mispronounce the Vogel case. Was it Schurman from the Court of Appeals? Would you mind addressing that, please?
So under Schurman, which was the unpublished Iowa Court of Appeals decision, which, if I recall properly, Your Honor, in and of itself indicated that that the Hart reasoning was appropriate and good reasoning, but then went against it, stated that a fee request is timely if made expeditiously and without undue delay, and where the opposing party suffers no prejudice. So let me address it starting with, we don't believe Schurman should apply at all. There should be and needs to be a final deadline, the 30-day deadline. Exclusive of that, even if the court wanted to accept some of the rationale under Schurman when we are dealing with this particular issue, it wasn't done expeditiously. There was certainly ample periods of time, but even if you want to say 31 days or 1 day after finality is expeditious, Schurman laid out the proposition that the opposing party suffered no prejudice. We have in the record prejudice in this matter.
You couldn't appeal? Is that your prejudice? No appeal? What would have happened? I think it's in the record, and it was in the brief, and it's a very good argument. What if they'd have just filed at 11:59 p.m. on the 30th day?
And they would have filed at 11:59 on the 30th day, Your Honor.
You wouldn't have had any time to respond. So I'm just not persuaded by that argument that you were harmed by that. Did you ever make any effort to say, hey, in lieu of me appealing, what's your position on attorney's fees? Was that kind of conversation ever included? Why was it a one-way street that they had to tip you off?
An issue of having to tip somebody off, Your Honor. When we're talking about jurisdictional issues, timelines are timelines. At up until the point in time, and Mr. Stoltze making the decision, Michael making the decision in terms of, it looks like we're going to allow bygones to be bygones and not have this matter addressed, then I'm going to let this go.
Until 30 days goes by, wouldn't it have been prudent maybe for your client to go ahead and file a notice of appeal, and then if nothing happens, just dismiss it?
I don't believe so, no. When we have these particular timelines and we have the ability to rely on those timelines, and more importantly, when we're dealing with civil matters, as regretfully I have certainly found out, a final time is a final time. There's no extending those timeframes on the appellate end. And yes, does another party have the opportunity to file that appeal up until that point in time? Most certainly they do, but they didn't. And that's the practical reality, and that prejudice does in fact occur to Mr. Stoltze.
Earlier, this was considered collateral.
Understood.
Collateral.
And I would go back to, I don't believe that this should be considered a
Collateral.
It's collateral. My assertion would still be, without a preservation, without a affirmative statement from the court related to an award of attorney fees, without a statement related to, or the opposing party having requested those matters, we're still dealing with a circumstance where it's not collateral, and under the statute itself indicating that it is a separate and distinct, I guess, money award from other ordinary costs. We have the ability here to indicate we need a time frame, we need a finality, we need that ending point. And in terms of, I don't want it to come across that the district court does not maintain certain jurisdiction, because certainly, as we know, they maintain the ability to enforce their prior judgments. They maintain the...
This then, if I'm understanding you right, under at least the quiet title context, this is kind of a form of damages. I think you said earlier it needs to be proved because there are certain statutory prerequisites before you can recover. But you've also said that they could have sought 1904-2 relief and tried to bring it up timely. I don't think that's right if you're right that this is a form of damages. Once you get through trial and you haven't requested it, then if you're right about this, then it's just too late, period. Is that the position you would take?
Yes, Judge, and I'd then also pivot back to one of the reasons in which perhaps an appeal isn't taken is that particular argument wasn't preserved. That particular argument wasn't dealt with, and there was no need in the Mr. Stoltze's eyes to perfect an appeal when essentially that attorney fee issue had been abandoned, and there was no evidence of it during the case in chief. And so I guess what I'm getting at in the other argument, and I see my time's almost done, can I finish? Is that the circumstances were, had it been properly before the court and not addressed, then 1.904 sub 2 would be the appropriate mechanism in which to do that. Had the court actually made a comment of awarding of attorney fees, then the application should have been filed within that 30-day time frame. And I see that my time's up, and if I may, Justice McDermott, I know you had a question. Can I, you?
Got to it with the Sherman question. Thanks.
Mr. Erbe.
May it please the court. Counsel. Good afternoon, Your Honors. I won't spend any time going through the procedural background. I think the parties agreed to it, and it's been fully briefed and also as part of the available court docket. The sole issue before the court today is whether there is an unwritten secret time frame for filing a post-trial application for statutory attorney fees. There is no Iowa Rule of Civil Procedure, direct Supreme Court precedent, or Iowa Code section that directly answers the question, including in 649.5 subsection 3, whether there is a deadline of 30 days or any other strict time period for filing a post-trial application for attorney fees. To follow up on what Justice McDonald had asked a moment ago regarding 649.53 and whether that should be argued and have evidence presented during the trial, I would submit that 649.53 is really a cost provision. It specifically states in that statute, in addition to ordinary costs, the district court can may assess a reasonable attorney fee. So therefore, that's a post-trial issue. And also, 649.53 is usually read as being a provision that only applies when there's success on the merits. It would be very inefficient, particularly in a case like this when we had competing claims under 649.53. Most likely, the district court will only have to decide one of the competing attorney fee claims, and it would be inefficient and a waste of judicial resources for the district court during trial to hear evidence from both sides about attorney fees, including all the things that go into an attorney fee application, the time spent, the attorney's qualifications. Does the attorney have to take the stand during the trial under the way that the appellant is arguing this?
All right, so your position is there isn't a 30-day deadline. What deadline is there, according to you?
Your Honor, without any statutory rule of civil procedure or Supreme Court guidance, I would refer to the Scheuerman v. Gum case and the analysis that it undertook in that case, in which it said that a motion that has no specific deadline found anywhere must be filed expeditiously without undue delay, which of course is very amorphous and does not mean a whole lot. I would certainly agree, Your Honor, if you're suggesting that there should be a set deadline somewhere, that could certainly be a potential proposed rule of civil procedure As I understand it, under the federal rules, there is a 14-day deadline for filing attorney fees post-judgment. I don't believe we have that here, so at this time, Your Honor, there is no deadline. But in this specific case, my application for attorney fees was filed on day 31, one day after the,
Do you wait till day 31?
if there would be any further work on the case to address any post-trial motions or appeals. And this court, in particular, the State ex rel. Weed v. Bechtel case from 1952, a case that went all the way to the United States Supreme Court before it ended. That case lasted years. This court said that attorney fees do not have to be sought until the work is done and the amount of time needed has been determined. So, Your Honor, I would not have been able to apply for attorney fees because I still wasn't sure. And under the way that the appellant has suggested, what successful parties would have to do is file repeated applications for attorney fees. Because if the appellant's position is correct, the successful party first has to move for statutory attorney fees before day 30 after the judgment. Then and at that point, there might not be a post-trial motion under 1.9042. There might not be a notice of appeal on file. Then after the initial application for attorney fees, there might need to be a second one if the losing party files under 1.9042 or files a notice of appeal. So now that's two applications for attorney fees. Then if there's an appeal and this court does not retain jurisdiction and transfers it to the Iowa Court of Appeals, that's another set of attorney fees. But under the way that the appellant is presenting the procedures, if the party succeeds in front of the Iowa Court of Appeals after it is transferred, they then need to still file another application of attorney fees instead of waiting to see if there's an application for further review. Because according to what the appellant is stating, all of these things need to be done before the next deadline in the appropriate rules. In that case, it would be the rules of appellate procedure. So then now it's 4 that are filed, and now you might have an appeal before this court if the court decides to grant further review, which could generate more briefing, oral arguments. And then at that point, do you file an application for attorney fees? Because now there's a risk that the next deadline is the petition for rehearing under the rules of appellate procedure. So at what point, Your Honor, do we have the ability to say that the successful party can wait to be sure that everything is done to avoid having to file 2, 3, 4, 5, 6 separate applications for attorney fees?
As a form, or like court costs, do our rules have a deadline for requesting costs after just any trial? If, you want your depositions used at trial, that sort of thing.
30 days, I believe, Your Honor. Yeah.
Or is that, because aren't costs collateral? Is there a 30-day deadline for those?
Code judge. Regarding collateral, as our Chief Justice was asking, I believe that the attorney fees are collateral. And this court has, at least according to the Scheuerman decision, suggested that attorney fees are separate and distinct from the underlying action. And that's different in some respects to, say, the Franzen v. Deering Co. case, which the appellant has relied on heavily. That case involved a motion for sanctions under what today is Rule 1.413. And the difference in that case is the attorney fees, the sanctions, were not statutory. They did not require a prevailing party. And most importantly, the attorney fees were sought for conduct that occurred during the underlying litigation in Franzen. Therefore, the sanctions could have been sought at any time after that conduct had occurred. Here, the appellees could...
Franzen, though, the court held that the district court jurisdiction ended when the summary judgment was affirmed on appeal. When did the district court's jurisdiction end when there's not an appeal?
For a matter, do you mean for a matter like these statutory attorney fees, Your Honor?
For any matter, when does the district court's jurisdiction end if neither party appeals? And no motions are pending at the time that the notice of appeal deadline runs?
I don't believe that this court has directly answered that question, Your Honor. I can go off of Scheuerman from the Iowa Court of Appeals that concluded that for...
Speak to that, though? Isn't that kind of the point, that when a notice of appeal is filed, that removes the district court's jurisdiction temporarily while it's on appeal? But if in Franzen we said, okay, once we affirmed the summary judgment, then there's nothing left. You can't go back into district court. Why does that reasoning not apply when there has been no notice of appeal filed? Why doesn't that then just say, okay, now the district court's jurisdiction is done?
I refer back to the Scheuerman decision, Your Honor, and I believe that the distinction that the Iowa Court of Appeals made in that case and that I'm making now is a difference between a motion for sanctions that revolves around conduct that occurred during the litigation and is wrapped into the underlying case, and what it is otherwise a statutory fee application, which is what we have here, that is separate and distinct from the underlying action. I'm relying on Scheuerman and the way that the Iowa Court of Appeals evaluated that in stating that the jurisdiction of the district court lasts for at least a period of whatever expeditiously without undue delay means. In that case, it was 47 days.
That 30 days in this case? Why is it 31 days in this case?
It's 31 days because I had to wait to find out if there was any more work that would need to be done on this case that would become part of my application for attorney fees. And I believed I could do that because of this court's decision in the Weed v. Bechtel matter from 1952. Going back to Scheuerman, as I noted, that case involved an attorney fee application in a trust matter that was filed 47 days after the district court's judgment, 17 days after the notice of appeal deadline expired. In that case, the Court of Appeals noted that there was also no 1.904 motion filed, same as here. But as my colleague noted, and as the Scheuerman court noted, this court had previously said in City of Hampton v. Iowa Civil Rights Commission that statutory attorney fees are not a Rule 1.904 issue, and that in fact, Rule 1.904 is not even an appropriate vehicle for seeking statutory attorney fees.
So, Mr. Erbe, if you're correct that a bill of costs needs to be filed within 30 days, I'm not finding that in here. I have to admit it's been too many years since I've been practicing law, 16 years since I've been practicing law. We often say that, you tax fees as costs, that expression is used, and even in the quiet title statute, it says the court may assess, in addition to the ordinary costs of court, a reasonable attorney's fee. That's the 649.5 that you're relying on here. So why wouldn't the same deadline apply as for costs if there is a cost deadline of 30 days?
If I may engage in a little statutory interpretation and try to parse out the two sections of that sentence in 649.53, I would submit that the important language is in addition to ordinary costs, and that the legislature separated the attorney fees from the ordinary costs by also making it discretionary. And my understanding is in many respects, the amount might be discretionary, but some costs need to be awarded to the prevailing party. So the words in addition to and the use of the permissive word may in 649.53 suggests that the attorney fee portion should be handled differently than costs, which makes sense because for an application for attorney fees, as many of this court's decisions have noted, such as the Great America Leasing case, there's a lot more that goes into that than just an itemization of some deposition charges and witness fees and a filing fee. The attorney has to provide qualifications, an itemized billing statement. So I do think it's different, Judge. And I do believe that any deadlines for ordinary costs would not apply to the statutory attorney fees.
Find that good cause is required for applications filed after 30 days, would we have to remand this for the court to make it a good cause determination?
I apologize, Your Honor, I did not catch the first part.
To determine that good cause was required for applications that are going to be filed beyond 31 days, perhaps maybe you could file an application on day 29, or at least talk, or let it be known that I have an application for fees. I'm not sure if it's going to grow. The number might grow. But I'm requesting the court give me permission to wait to see if there's an application or a notice of appeal. Is that something that could be done, that could have been done to present? You're talking about duplicative filings. Couldn't you just file one to put dibs on it?
And alert the court to?
Everybody, hey, I've got a fee request here, instead of waiting to the gotcha 31 days.
Yes, that could have been done, Your Honor. You also had a question about good cause, though, and whether the...
Is there any good cause to go beyond 31 days for attorney's fees? If that were true, wouldn't we have to remand it back and have the district court make that determination if there was good cause?
And one reason why there might be good cause is at the end of the day, on day 30, I see my time is almost up. May I have a moment to conclude? At the end of day 30, at 11:59 that day, there could be a notice of appeal filed. And that's my good cause for waiting to day 31, is I needed to see if there was so that's my reason for good cause, as I understood Weed v. Bechtel allowed. Thank you, Your Honors. For all those reasons, I respectfully request that the court affirm the district court's decision. Thank you.
Thank you. May it please the court. If I may address some of the issues that came up, first and foremost, and respectfully to my colleague and friend, Mr. Erbe, the concept of repetitive filings, that argument simply doesn't hold water. The practical reality is one filing will preserve the request for attorney fees throughout. Had a filing been done timely within the 30 days and no appeal was taken, well, there we have, abracadabra, we have the point in time that we needed. Had that filing been done and then a notice of appeal was taken, lo and behold, when we get to the point of having to have a hearing on attorney fees, that issue is in fact preserved. Additionally, the examples that were given related to whether this court transfers it to the Court of Appeals, whether there's a application for further review, I frankly don't understand, because none of those circumstances are finality. What happens on a appellate matter, as this court is painfully aware, it's final upon the issuance of procedendo. Nothing's final on an application for further review or anything else of that nature. So we're not talking a situation of judicial economy to avoid multiple filings. One timely filing would have preserved the attorney fee issue.
Just to kind of like pretend that 649.5 somewhere in there has a magical deadline. It does not impose a deadline, and you're also assuming that it's not collateral. So isn't there some room for discussion?
Of course, there's room for discussion, but we're not asking this court to assume anything. We're asking this court to follow the prior precedent that's been issued from some of the cases, and those cases being Franzen for one, those cases being Smith v. Wolf, and the case that the Appellees rely on so heavily was not from this court. It was an unpublished decision of the Iowa Court of Appeals, and when we're asking the court to follow this precedent, it's the precedent and what appears to be very unequivocal language. When a final judgment is done, we're finished in this circumstance. And so as such, that would end that determination. And I believe the question was asked about the 1159 filing before, and would that have prejudiced the Mr. Stoltze at that time, we're not talking a notice issue here. That's not the discussion. Our discussion is a jurisdictional issue. Had they slid it in, I guess, at that point in time, most certainly that would have been allowed. But they didn't.
The 1952 case from Weed that the other party seems to rely pretty heavily on.
Respectfully, Your Honor, I would like to be able to address that case, but I did not see it cited within their brief, and
Cited in the Sherman case from the Court of Appeals. From that case talks about it being, that one was filed 5 years after, and kind of talks about prejudice, but if you don't know the case, that's fine too.
And Judge, if my memory serves, after looking and the court reminding me of that, I do believe that particular case did deal with a prejudicial factor and whether there was, in fact, prejudice that could be applied. And because of the length of time and the facts and circumstances, I believe the court found in that case that there wasn't a prejudicial effect within that. We don't have... Yep.
Am I correct that in that case, it was a dispute between, it was the equivalent of a client-attorney dispute, not the two parties? And the court says something about like solicitor versus something like that. That's my recollection. It was some situation like that.
To be completely frank, Your Honor, that the facts of that particular case are not coming back to me at this time. I apologize. Following up on some of the other discussions related to questions that had been asked and the collateral and whether or not we had a final determination and or good cause, I think was also brought up. First, we would submit that it's not a good cause determination because finality is finality. I believe this court has also ruled that there is no good cause analysis for a civil matter in a delayed appeal. And as such, the court determined that it was final at that point in time, unlike in a criminal matter where there may be a good cause finding for a delay of an appeal. So when we have that 30-day time frame and the court is divested of jurisdiction, final should mean final. Unless there are any other questions, we'd ask the court reverse in the appellant's favor. Thank you.
Of Stoltze versus Stokes is hereby submitted and court is adjourned.